A Chicago public schools security guard, whose job was to protect students, is now accused of sexually assaulting two teenage girls over several years, and court documents reveal especially disturbing details. 48-year-old Heather Pancer is facing 2 felony counts of criminal sexual assault, and prosecutors allege that this abuse happened right under the school's nose. We are going to break down the horrifying details of this case with a Chicago-based trial attorney. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. We cover, unfortunately, a lot of cases like this. Usually, it's a teacher that's accused of crossing the line with a student. We cover that almost every week. This time, this story, it's somebody else inside the school. It's very different. Somebody whose job was, ironically, to be keeping kids safe. A Chicago public schools security guard is now accused of sexually assaulting 2 teenage girls over several years. Prosecutors say they allege that 48-year-old Heather Pancer allegedly abused these girls between 2018 and 2021 while working at George Washington High School. And what's in this newly released warrant makes this case even more disturbing, because investigators say that Pancer actually sent a photo of herself in bed with one victim to the sister of another victim. Yeah, let's process that allegation for a second. So, before we even get into the really disturbing parts of this warrant, I want to back up because this case is very wild. This all centers around Heather Pancer, a Chicago public school security guard who, again, worked at George Washington High School. This is on the city's southeast side. And investigators claim that between 2018 and 2021, while she was supposed to be protecting students, she was actually sexually assaulting 2 teenage girls who attended the school. Now, according to court documents that were reviewed and cited by WGN, the first victim had apparently told investigators that this abuse started around September 2018 when she was just 15 years old and allegedly continued through December 2019. That's a long time period. And during that time, prosecutors claim that Pancer not only assaulted her multiple times, but also maintained contact with her even after the student left the school. And that is when things took an even darker turn, because according to the same warrant, investigators allege that Pancer had sent a photo of herself in bed with a second victim and sent it to the sister of the first girl. That's how detectives say they discovered there was a second student involved. And that second victim, who was also apparently a student at George Washington High, told police that her abuse happened between February 2019 and March 2020, when she was 16 and 17 years old. Now, her family had already suspected that something was off, so they told police they thought her relationship with Pancer was, quote, abnormal, that Pancer was buying her clothes and shoes, which, allegation being very, very weird. Now, the victims were later interviewed, and this is important, during what's called a CPD lock-in. This was at the Chicago Children's Advocacy Center, where they gave detailed statements about what had happened. Now, a lock-in, or forensic interview, if you're not familiar, is a scheduled, structured interview session that's organized by police where victims, often minors, can provide detailed statements about sensitive allegations in a safe environment. Very important to have this. And after that, a warrant was issued for Pancer's arrest. And according to Cook County Sheriff's Office records, she turned herself in on October 15th. After news of her arrest broke, Chicago Public Schools, they released a statement confirming that an employee had been taken into custody. Quote, Chicago Public Schools, CPS, remains committed to maintaining safe, ethical, and supportive learning environments for every student and staff member. The district continually reviews and strengthens its safeguards, including robust ethics training, oversight procedures, and accountability measures to protect our school communities. CPS actively works to prevent sexual abuse and addresses all reports of abuse thoroughly and all the appropriate investigatory departments and agencies. District leaders and staff continuously strive to educate leaders, faculty, and students on the topic and the reporting process. Employees are expected to follow all rules and policies set by the Chicago Board of Education, and there are processes and procedures for reporting and investigating any alleged violations. While CPS does not comment on specific personnel matters or active investigations, the district follows a consistent process when allegations of misconduct are reported. Employees found to have violated board policy are subject to disciplinary action up to and including termination. So it's important to understand what criminal sexual assault means under Illinois law, because that is exactly what Heather Pancer is charged with. So to help break down all legal aspects of this case, I want to bring in Bryce Hensley, who is a Chicago-based trial attorney, deep experience in institutional sex abuse cases. Bryce, thank you so much for coming here on Sidebar. We really appreciate it.
Thanks for having me, Jesse. Appreciate it.
Before we got on, I said, and this is something I mentioned at the top, we usually cover cases where it's educators, where it's teachers, coaches who are accused of this. To have a guard accused of this is something that you've seen before, and how do those cases differ?
Well, it is something we've seen before. I mean, unfortunately, the Chicago public schools as a whole have a sordid history of sexual abuse and sexual assault from individuals in positions of authority. And this isn't just limited to teachers. It expands out to administrators, staff members, and unfortunately, we have seen circumstances with security guards in the past where something like this has happened.
How do prosecutors decide, okay, these are the charges that we're going to file in a case where, let's say you have a school employee, maybe not a teacher, maybe a guard, is accused of sexually abusing or assaulting multiple minors over several years? What are the charges that you could be looking at here? And when you talk, and we'll talk about the specific charge that's being leveled here, but how do you determine what the charges are?
Sure. So, I mean, a prosecutor is going to look at a wide variety of circumstances. They're going to look at the various statutes. Under Illinois law, you have statutes for things like criminal sexual assault, criminal sexual abuse. Then you also have aggravated criminal sexual assault, which in a circumstance like this is a very likely charge that could or should be brought, mainly because an aggravated criminal sexual assault typically will involve an individual like this who is in a position of trust or authority.
Now, obviously, this is a story that we wanted to bring to you. And the reason that we can keep on doing it, the reason we can put out this content is because of the incredible support that we get from our sponsor, Morgan & Morgan. This is America's largest injury law firm. This is a firm with over 1,000 attorneys. You know why they're so big? Because they win all the time. They have recovered over $25 billion for more than 500,000 clients. Think about that. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. Out in Pennsylvania, a client was awarded $26 million. That is 40 times the insurer's $650,000 offer. Another client in Pennsylvania received $29 million after being offered only $500,000. And even if you think that your case isn't worth millions of dollars, why not just start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar by clicking the link below or scanning the QR code on screen. The alleged sending of a sexually explicit image of one victim to a third party in and of itself is pretty shocking to say the least, but how does that escalate the case? How does that escalate maybe the severity of the charges under Illinois law?
Sure. So there are a variety of statutes that are out there that can govern the sharing of material, sexually explicit material, especially if that sharing of explicit material involves minors. So prosecutors going to look at all of those facts to determine under Illinois law which portion of the statute they should bring charges under.
What's the evidence so far in this case that stands out to you that maybe was a challenge in collecting, or maybe that's going to be very important for prosecutors in securing a conviction here?
Well, I think in a case like this, I think the information that you're going to be relying on a lot is testimony from the victims themselves. In my role here on the civil side, we are always looking at information about what the school knew and when. And a lot of that goes beyond just the facts of this specific case. In the criminal case, you are going to be confined to the facts of this case. But on the civil side, you're always looking at the policies, the patterns, and the practices within the Chicago public schools, which, as you may or may not be aware, and I'm happy to go into the details on this, is extremely, extremely detailed.
So what do you mean by that?
So back in, I believe it was the late 2010s, the Chicago Tribune actually released a series. They called it the Betrayed series. And the whole impetus behind it was this feeling that people within the Chicagoland community felt like the leadership, the people that are in these positions of trust and authority, were betraying the students and the parents that relied on them to take care of them. And so you can imagine you go and you drop your kids off at school every day. It's the last place you'd ever imagine that they would be subjected to something like this. But what this series found was that on a weekly basis, literally a weekly basis, over 500 allegations of sexual abuse taking place at the Chicago public schools in a 10-year period of time. It was shocking to hear that. But as you look deeper into things like the Office of the Inspector General, which conducts reports into specific allegations of abuse, you'll find that at some of these high schools, you have cadres of teachers that are abusing students at the same time, grooming them, preparing them to be abused, both while they're minors and immediately after they're graduating. And so this is something that the Board of Education, the Chicago schools, have known about now for decades and have refused to curtail. This is just the latest in a long line of incidents that they've had to encounter and face public scrutiny over.
Yeah, and this one's now getting a lot of attention too. That's a pretty disturbing point that you make. We mentioned before the purpose of lock-ins, right? These CPD lock-ins, and I imagine they might be used in a lot of these cases, right? Where you create a situation where these alleged victims, these minor victims, let's say, have an opportunity to reveal this information in kind of a controlled, safe setting. Can you talk to us a little bit more about how these work and how important they are for a prosecution's case?
Yeah, I mean, I think it's vital to prosecution case, and I think it's vital to ensuring that victims are heard. I think too often what you see in these situations is that the individuals that are charged are people that these students come to know and to trust. Right. And so when that trust is broken, there's an inherent distrust that's then fostered where they don't feel like coming forward. And so these lock-ins where they're basically hosting these events to come and have people talk about what they've experienced are critical. We see it time and again where people are afraid to come forward. And it isn't until that first individual does that the floodgates start to open and more information is revealed over time.
What are defenses to something like this?
Well, it's a great question, and candidly, I'm not too sure. On the civil side, a lot of times what the school districts will try to argue is that they didn't have notice, right? That they didn't know that this was going on. These were the actions of a one-off rogue individual who was doing this on their own time, and the school district couldn't possibly have known. But again, when you have decades of this kind of behavior, it raises questions with respect to hiring practices. How are you conducting background checks when people are hired? How are you supervising these individuals? Are students being left alone or put in a position where they have to be left alone with these people? And especially with the CPD's history, they have to be aware of this and they have to take steps to ensure that students aren't put in a precarious position with people who are predators. On the criminal side, it rises to a level of intent, but unfortunately, when you're dealing with somebody who is a minor, the defenses really kind of go out the window. There's not a specific intent requirement, and if you're caught with somebody who is underage, like it appears that this security guard was, the number of defenses that are available to you are severely limited.
I mean, suggesting it didn't happen. This is totally a lie, which can be complicated when you have digital evidence, right? So I want to talk a little bit more about the charges in this case. So you have here 2 counts of criminal sexual assault. Now, in Illinois, this isn't a misdemeanor. It is a felony. It is a serious felony. Under the Illinois statute, this is when someone, our understanding, commits criminal sexual assault when they commit an act of sexual penetration. And then there's also this other component that one of a few specific things is true. Here's a key part: position of trust or authority. That's what prosecutors often lean on when you have a teacher, a coach, a school employee accused of crossing a line with a student. Bryce, can you explain to us why you have that specific carve out here? How that changes the way the case is charged, and how we define a position of a trust or authority? Would that be a guard?
Absolutely. I mean, especially at a school, at a CPS school, right? I mean, you have these people, they're mandatory reporters under the law. If you're working in a Chicago public school, you are a mandatory reporter under the law. And these individuals are put in this position and they are held out to the students as individuals. They tell students, if you have an incident where you are being sexually assaulted by somebody, whether it's a family member or a teacher or a security guard, anybody, and you report that, the onus is on that individual, including the security guard or the teachers of the school, to make a report to DCFS and other law enforcement agencies. And so it's all about the representations that the schools hold these people out to, right? I mean, you are cloaking these people in authority by saying, These are security officers. These are people that are there to protect you. They're there to ensure that there is public safety. And it is the school district that is bestowing them with this title, with this authority. And yet they're the ones that are turning around and abusing, assaulting, and in some cases like this one, raping the students that are there. And so it's absolutely something that is warranted by the charges that have been brought as you read the statute.
Yeah, that power imbalance is key. We see that in a lot of different states, why they have these specific laws on the books. Just to be clear, if you have alleged abuse that continued outside of a school setting, outside of school hours, off school grounds, in your experience, does the position of trust element, would that still apply?
Oh, absolutely. And I think it's one of the main reasons why you see in the Chicago public schools, they have policies that they're supposed to be following, that they're supposed to be instructing their teachers on, that there's not supposed to be contact with students like that outside of school. And I don't just mean sexual contact. I mean doing favors for students, giving students rides home, because the policies lay out the exact line of thinking that's there, which is the school district knows that if you start breaking down those walls where teachers or security guards can start taking students home from school, off of school property, they start doing little favors. That's grooming. You're beginning to groom these students, and you're beginning to set up a situation where the comfort bounds are being broken down between the students and these individuals with the positions of trust and authority. And so while I don't know all of the facts of this specific case, what we've seen time and time again is that these relationships, they begin on school grounds. There are signs, there are pieces of evidence that begin showing up that show a relationship starting to form. And then it's the little steps over time, right? It's, hey, let me give you a ride home. Oh, your mom couldn't pick you up today. I can take you to the park. I can take you to your basketball game. And what that does, especially for students, young students who, again, see these people as being in a position of trust with them, they begin to put their trust in these people. And that's typically what the predators look for, right? They begin to form these relationships where gradually over time they can start taking advantage of these students who frankly don't know any better, and they shouldn't know any better. They're children.
It's an important point. I want to get to that as we talk about, grooming tactics in a second. But just to go back to this, I mentioned it's a serious felony. It's our understanding under Illinois law, we're looking at a class 1 felony. Comes with a potential prison sentence, our understanding of 4 to 15 years. Please correct me if I'm wrong, but if that is true, if she takes this to trial, if someone like this is convicted, given these allegations, and you're looking at 2 charges, what potentially could a defendant look for here? I mean, what could they be looking at?
Well, I mean, there is a very real possibility that these charges are levied against the defendant, and they're levied consecutively, meaning if the court finds based on the evidence that the charges warrant the maximum penalty, possibly the 15 years, there is a possibility of that individual going to prison for decades. I will tell you, we just had a case here at our office where an individual was accused of something very similar. This was a dean of students at a Chicago public school who had a relationship, and I struggle to even call it a relationship, but basically began a grooming situation with a student, carried that out over years, and he was just sentenced to 22 years in prison for what he did. And that was a finding of an aggravated criminal sexual assault and some other lesser included offenses as well. But 22 years in prison. So I would imagine here that the prosecutor is probably going to pursue the full extent of that. Based on the evidence, they're going to pursue as much as they can, and that could be decades of time in prison.
There's a detail here that we were kind of talking about before in the Pancer warrant that immediately brings to mind a pattern that we've seen in other school employee misconduct cases that we've covered or talked about, because investigators say they allege that Pancer bought clothes and shoes for one of the victims. Now, on its own, might seem pretty innocent, but prosecutors, they often present that kind of behavior as grooming, right? Part of establishing trust, breaking down those walls, those barriers, that dependency before the sexual abuse occurs. And we've seen a strikingly similar dynamic and allegation in the Brittany Fortenberry case. For anybody who's been following us on Sidebar, you know about this, because according to the Fortenberry affidavit, one alleged victim said that she purchased $600 worth of clothing and shoes for him during a mall trip, only to later bring him and his friends back to the house to be abused. Now, Bryce going back to this, when prosecutors bring up these things, the clothes, the gifts, the clothing, the timeline, that tells a story, that tells a pattern. What is their ability to bring all of that in, and how do defense attorneys fight back against that? Do they say, hey, this is overly prejudicial, this isn't relevant, oh, it's innocuous, you're making more of it than it is? But it does tell an important part of the story if you're looking at precursor behaviors, right?
Right. And certainly a defense attorney is going to try to keep that evidence out as much as possible. But I think what most capable prosecutors would try to do, or at least what we would do on the civil side, is we would likely bring in a psychological expert that can talk about this pattern of behavior and why it leads to this type of conduct, right? You've hit the nail on the head. It breaks down the walls, right? You have an individual who is already being held out as being somebody that these children should trust, should be able to go to. And now all of a sudden, this person is beginning the grooming behavior by doing these small favors. And those small favors, they build up over time. And it increases the trust more and more and more until all of a sudden there is that defining moment where the predator is going to make a physical gesture of some kind. And at that point, a minor student psychologically has already been preconditioned to trust this person, both by the school, but then also by these actions over time. And so it's not surprising that this is the exact pattern that we see time and time again, both in this case and the Fortenberry case that you just mentioned.
And speaking of the patterns that we've seen before, I just want to quickly talk about another case that also shows how someone in a position of trust can allegedly exploit their role, because we go back to Alabama. There was Michaela Caldwell-Hodgins, this cheer coach, this teacher, who on the surface seemed to have the dream life, a college sweetheart, 2 kids, job she clearly loved. She'd grown up in the area, cheered on a scholarship at the University of West Alabama, returned home to coach at Randolph County High School, and there were posts that were welcoming her to the school. They highlighted her experience, her local roots, excitement to build the cheer program. Again, her life seemed picture perfect. However, a Randolph County grand jury indicted Hodgins for allegedly having sex with a male student. And these allegations revealed a darker side, potentially showing how someone in a trusted position can allegedly cross serious boundaries. Because Hodgins' case was particularly shocking since it came from a small community where people likely knew her personally. It makes the alleged breach of trust even more striking. And the reason we're bringing it up is because it kind of echoes the dynamics that we see in the Heather Pancer case. Someone in a role meant to support and protect young people, allegedly using that trust to manipulate and harm them. And it is a pattern that prosecutors often highlight to establish grooming and power imbalance and premeditation. But Bryce, you also think about it here, it's hard to imagine this happening, right? It's hard to think about this happening. And I wonder if that ever becomes difficult for prosecutors to say to a jury, despite all outward appearances, despite maybe nothing in the past, despite someone having a perfect home life, everything's perfect on the surface, to do this. Do you think it's hard sometimes to find a jury that will believe somebody could do something like this, unless you have just concrete forensic evidence or digital evidence?
Jesse, it's interesting. I think if you'd asked me this question a decade ago, maybe even 5, 6, 7 years ago, I would say you're probably going to run into that inertia with the jury, right? Of getting over this hump of, these people who tend to, on the outward appearances, are the perfect candidate, right? I'm thinking of a Chicago public school teacher who I think 2 years prior to revelations about his misconduct was awarded the Chicago Teacher of the Year or something similar to that, right? He's held out as being the top teacher in the district. And yet these revelations come out. But I think nowadays what you're seeing more and more is the availability of digital evidence, whether it's on Facebook, Instagram, Snapchat is a popular one too, because people think that with the disappearing messages, they can't get caught. But in a lot of ways, what happens over time is these predators, they become emboldened, right? It starts off where they're very cautious about what they're doing. They make sure to cover their steps. They also will make sure to emphasize to the victims why they need to keep it quiet. And that's another grooming tactic that we see time and time again. But over time, as these relationships go on, these inappropriate relationships, you see that those walls start coming down. People get sloppy. People begin sending messages where they shouldn't be. And eventually what happens is that evidence goes before a jury. And so the defense in these cases can hold these people up as being these paragons of the community. But more and more what we're seeing is that the digital evidence and the digital footprints of these individuals are becoming too much to overcome. And so I think that juries are obviously in the modern day and age always looking for that type of evidence. And we're seeing it more and more. And it's incredibly difficult, I think, for these perpetrators to cover up this extensive misconduct, especially when it's taking place over weeks, over months, over years.
And just to add to that point, if you have somebody who's charged with abusing multiple victims over a period of time, do you usually see that in one trial, or will you have defense attorneys who will say that's overly prejudicial, that there are parts to one allegation that maybe prejudice the concrete allegations, the concrete set of facts for one victim, or do you usually see all these cases grouped together, multiple victims all coming together, all the evidence? I wonder how that works exactly.
Yeah, I would think in the criminal sense, you typically have individual trials. I think the point that you raise is spot on, that defense attorneys are going to raise the flag of prejudicial evidence and having to prove cases within a case. On the civil side, though, more frequently what we're seeing is that courts are open to consolidating these types of cases and allowing victims to come together and voice their feelings as a group. And I think that's the right decision. At the end of the day, when you have these people that are carrying these types of actions out against minors and against vulnerable individuals, people that are trusting them, I think that evidence has to come in to demonstrate things like motive, opportunity, all of the things that we know that there are exceptions to the rules about prior bad acts and things like that coming into evidence.
No, that's a good point. And look, for Pancer, she's being held without bond ahead of her November 5th court date. Just another disturbing set of allegations. But Bryce, thank you so much for taking the time. Really appreciate it.
Yeah, thank you. Appreciate you having me on.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.